And where I left off, or at least where I think you guys stopped, let me go back to sharing the exhibit. It was on this, after this first paragraph response to number 6, the last thing I heard was these incidents began early from the first week I started on location at the east side branch. And so we've got, starting here, I think is where you left off, Mr. Michelle.
Okay, so I will continue from there. In the evidence I submitted, my original complaint, there is an email Barbara sent to me from Kyle Paulson, work email address, mentioning what appeared to be an innocuous message stating, Willie, this is Barbara using Kyle email. We have some voucher for you. And a smiley face. This message was a subtle message of what to come. It was a message that Barbara was sending that she can break the rule and get away with it. Confused and perplexed and trying to appease the onslaught from Barbara, I replied, thank you. Certainly, Barbara did get away with it. For any reason other than a serious emergency, a colleague should not use. Yes, it should not use another colleague's email and sign on to send a message purporting to be another. As I mentioned above, this email was a clear message that Barbara was hinting to me that her and Kai was about to harass me, discriminate against me, breaking rule to do so and get away with it. These incidents occurred from November 2015 to February 2016. Should I continue?
Nope, that is it. So in this space, in response to the ERD's request that you identify all acts of harassment that you experienced at the bank, you discuss alleged harassment at the hands of Barbara and Kyle, correct?
Yes, as it pertains to this, what we're discussing here, that's what I put at that point. Yeah.
Okay.
That's what I put down.
And, but you didn't list any other harasser, did you?
Yes, and I believe that's the East Branch again. Yeah, exactly. I didn't listen to any other harasser than those two. Yes.
Okay, all right. And the question didn't ask you about the East Branch, correct?
Say that again.
I said the question from the ERD wasn't limited to the East Branch, was it?
I don't believe so. It's likely that's my understanding, and again, yeah, that's my understanding. That's how I replied to it.
I'm sorry, I don't understand. That's how you implied to it?
That's how I replied to it.
Okay.
It's on my understanding at that point. Yep, that's what I put in there. Again, yeah, that was a rebuttal that I quickly have to respond to. Yep, that's what I put in there.
And you wrote this, down, correct?
Say that again, Attorney Williams.
Yeah, no problem. So this document, if you go to the first page of it, one of 8, this is dated December 1st, 2018, correct?
Just one second, I can get up there. There we go.
That's the date that I put down, yes.
Yeah, okay, all right. And then if you go and look at exhibit number 5, and you don't have to unless you don't recall, but that document is dated November 19th, 2018. Is that correct?
Okay.
I see November 19, 2018, yes.
Okay, so you had some time to put together a response to question number 6, correct?
Okay, I'm looking at November 19, 2018. What was the date again that I put mine?
December 1st.
Then
Yes.
2018?
Yes.
Okay, now the rules and laws, I'm not an attorney, I don't practice that. I think they give you 20 days or 21 days. Again, that's why I know you mentioned a yes or no. I'm trying to, so again, I got all the work and I type slowly. That's one of my things. I type very slowly, go over. Yeah, so that's time it take me, to put that. And those are the information that I gathered at that time. address
Okay.
with us.
But
Yeah.
I think the point is that you only listed harassment at the hands of Barb and Kyle in response to the ERD's request that you list all acts of harassment. Is that correct?
Based on my understanding of the question at that time, yes.
Okay. And then on this document, so looking at page 6 of 8, the very last sentence, you write, so the very last sentence in that section 6, you write, quote, these instances occurred between November 2015 and to February 2016. Is that correct?
Exactly. And that's based again on my understanding of the question. Yeah, I go from when I start the job up until February 16 when I complain to HR. Yes. Based on my understanding, that's how I answer that.
And did you understand the question to be limiting your response to the time that you were at the Green Bay East branch?
Let's say that again.
Did you understand the question from the ERD to be limiting your response to just your time at the Green Bay East branch?
I did not read that again, unless I see it in front of me. That's page by page I'm reading as you are directing me through it. So again, if the question was they're limiting me to what happened at the East Branch, likely that's what I respond to.
I'll
Yes.
show you the question again,
Yes.
just a second.
Thank you.
Okay, so we're talking about question 6.
It's okay. Yeah, which is for each time you were harassed. Yeah, my understanding of this one is my understanding of this, it's for each time I were asked, and I base that, of course, yes, on what happened at the East Branch. Yes.
Okay, all right.
Mhm.
And in responding to this question about each time you were harassed, um, when you indicated that the harassment occurred between November 15th and February 16th. I'm sorry, November 2015 and February 2016, you were being truthful in your statement there, correct?
Everything that I say is truthful, yes, integrally with the whole complaint.
Now, Nate looked into several of the issues that you had with Barb and Kyle. Is that correct?
Yes, at some point, as I mentioned earlier, yes.
Okay.
We talk either a
Yes.
few times, yeah, one-on-one, and I try once, yeah, to be with Carl to talk with them over, yes.
Okay. All right. So I want to turn back to exhibit number 18, Judge.
Okay, just gonna. Okay.
And then
This
I want to go to the second document within this exhibit, which is the email.
this email here.
Yeah, that we talked about. So I believe you referenced Mr. Michelle this email when you were identifying all the reasons that you believe you were harassed at the bank. You referenced this email, correct?
Your question is,
Yeah,
I
no, I can restate. I can clean that question up. So we were just talking about exhibit number 6, correct?
uh-huh.
And in exhibit number 6, you responded to a question from the ERD that asked you to list all harassing acts that you experienced at the bank, correct?
I did mention that email. I did mention that email. The context in what I just read, though, that was an indication. I believe that's what I read. That's an indication of what's going to happen. That's what I read. Yeah, that's the context that I put it there. Yeah, because that's
Okay,
what the
so
email.
Okay, so just so we're clear, looking at exhibit number 18, the second page of this is the email that you were talking about in your response to the ERD that we just.
Exactly. That's the one that I refer to. Yes.
Okay. And your position is that this was a form of harassment or a harassing act. Is that correct?
It was a form, yeah. It was a form, yeah. That's in the context that I use it, that it's telling me what's to happen. That's a prelude, basically. Baba was a message, put it that way, a message Baba was sending to me of what's going to happen.
Okay. And how is this harassing?
Well, how this email is harassing,
Yes.
that's your question. As I
Yeah, that.
mentioned, this is a message to me, this is a message to me that tell me what to expect. It is an innuendo of the harassment that will take place as I go to the that's my answer to that. That's our answer now.
Okay. Okay. So in this exhibit, let's scroll down a little bit and go to page 4.
Page 4 of his statement.
Yeah, page 4 of his statement. Sorry, Judge.
Okay. Okay. So that's page 4.
Okay, so on page 4 of this statement, the first full paragraph starts with, "It was about that point." Do you
Mhm.
see that? Okay. Can you read this paragraph? You can read it to yourself, you can read it out loud, and when you finish, look up.
It was about that point that Kyle washed into the back office where we were talking and said in short, "You too loud, I can hear you up front," which really was not. It was a preface of an attempt at assaulting me. At that point, I can see in Kyle's face that he was angry and ready to take action. I then said, "Okay, Kyle, we were loud. I'm going to close the office door for a moment." Kyle objected loudly, "No, you are not. You are not going. You are not. You are going to the teller line. I'm not going to let you speak with her that way." At that point, it was Bob speaking. At that point, it was Bob speaking. But as soon as Carl stepped in, she did not say a word through the whole short conversation. I then pretend everything was still okay and hold the door handle and told Carl that I'm going to close the door for some privacy. As soon as I hold the door handle, Carl immediately take his fighting posture, put his right foot blocking the door and ready to attack me. My hand has slightly touched the door handle and it was jammed tight against the wall. I saw the situation escalating, and in fear at that point, I suddenly stepped back deeper into the office and said, "I'm going to call Nate."
Okay. All right. So in this paragraph, do you see where it says that Kyle said to you, "I'm not going to let you speak with her that way"?
You want me to read it again? But yeah, I do believe I just read that.
Okay, okay. And is it fair to say that he had a problem with the way you were speaking to Barb?
That's yeah, based on what she said. Yes,
Okay.
that, that's what.
And then
Uh,
going down a little bit further in this document, you write that Kyle, quote, "Kyle immediately take his fighting posture." Do you see that?
Go back over again, Mr. Bullocks, if you would
Yeah,
please.
no, I'm sorry. So at one point in here, you say that Kyle immediately take his fighting position. I think the judge is her.
Yes. Yep. I can see
Okay.
that she's kind of highlighting over it. Yes. Uh-huh.
Okay. So he must have been really upset. Is that correct? Is that fair
He
to say?
was angry. Yes.
Yeah,
He was
he kind
angry.
of pressed his buttons.
Say that again, sir. I
His
do
his buttons
apologize.
were pressed.
Huh?
His buttons were pressed.
I'm sorry. I think I got you. You use a little bit not legal language. You say his button was pressed. Is that right?
Yeah, yeah,
Which mean he was mad.
yeah. He was
Give me
mad
the
at you.
meaning,
Yeah.
okay? Now, my English is my second language. I got again, it's my second language. If once you leave thing I cannot find clearly in the dictionary, give me a little bit of problem. Button press, that mean he was angry, or again, I'm inferencing to get what you really meant. You meant that I push his button annoying him?
Yes, yes, yes.
No, if
Okay.
that's what you mean. We want
Okay.
to be clear with him. No, I did not push his button, if that's what you mean. No,
Okay. But he was pretty upset to get into a fighting position.
he
Would
was
you agree?
angry. Yes.
Okay. All right. Fair enough. All right. Now, Mary Connaughton investigated the issues that you reported about Barb and Kyle, correct?
It is alleged.
So, do you have reason to dispute that she investigated
I do.
your allegations?
I do.
Okay. Did she ask you questions about your allegations?
Yep, I did talk with her. Yep, I did talk
Okay.
with her. Yeah, I
And,
did talk with her.
and do you know whether or not she spoke to anyone else about the
That I
issues you
don't I have
raised?
no idea. There's no way to verify that. Right?
Okay.
That person,
All
yeah,
right. All right.
independently.
So you have no reason to dispute that she talked to other people, correct?
It's the way you ask me the question here. I do. I do. As part of me, I do. Again, I don't know if, I don't have a way to verify if she did, but I do have to dispute that. I guess the way you ask me the question. I
Okay.
do
Well, do you
dispute that
have
she's
any?
investigating.
Okay.
So the question again, I guess I'm going to answer it for you. You mean,
All right. Thank you. So you don't have any evidence to suggest that Mary did not investigate the claims that you brought uh, about Barb and Kyle by talking to other people.
I don't have physical evidence. I don't have
Okay.
physical evidence to say that it did not or not. Yeah.
Okay. At this point, I want to introduce exhibit number 19.
Okay, so that's exhibit 19.
Yep. And I believe this was discussed earlier as well.
Yes.
So Mr. Michael, on this document, this is a letter from Mary to you, dated March 4th, 2016. You received this, right?
Yes.
Okay. And in this letter, she writes, the first paragraph, that as we discussed on February 29th, 2016, I did not identify any harassment or retaliation. However, the work environment was not comfortable work environment to be working in, correct?
I do read that. Yes.
Okay. And this was in March of 2016, correct?
Yeah, that's the
Yeah,
date. Yeah.
yeah, yeah. And your employment wasn't terminated anytime soon after that point, correct?
It's after that.
Right. So, but your employment wasn't terminated in 2016, correct?
No, it was 2017.
Right. It was towards the end of 2017, right?
Yeah.
Okay. Like,
September 17. Yeah. You can say that almost at the third
okay.
quarter. Yeah.
All right. All right. I want to now direct your, well, actually, before we go there, you mentioned earlier an annual employee survey that you filled out. Is that correct?
Employee survey. Yes, I did fill one. Yeah.
Okay. And when you filled that out, did you put your name on that document or that submission?
I can't recall.
Okay.
I can't recall, but again, as I did mention, I wanted to send whatever light I wanted to send a message, but I can't recall if I put my name or not.
Okay. And do you have any evidence or any basis to dispute that those surveys those surveys come in anonymously?
Let me try to explain. Those survey came anonymously to me, or I
Yes, it's fair. Yeah, the surveys go to the bank anonymously.
or after that I do them.
Yeah.
I don't know how that's work. No, I don't know how that's work.
All right. All right. Fair enough. All right. I want to direct your attention to exhibit number exhibit number 31. So exhibit number 31 is a copy of our discovery request to you in this litigation.
I would say so.
Okay. And then I want to go to page 12 of this document. Okay. In interrogatory number one, asks you to identify, I'm sorry, Judge.
That's okay. I'm almost there.
Yeah, questions on here are really short.
All right. So there's page 12, interrogatory number 1.
Okay. So interrogatory number one asks you to identify each and every act of discrimination taken by the bank. Is that correct?
You want me to read it? I mean, it's best to read it.
Uh,
It's a lot of information.
yeah, if you want to read it, that's
Just for me
fine.
to agree with you. Sometimes I hesitate, to just agree on what you tell me by yes, by just saying yes on the record. Okay? Or in case it might be no. So I'll make a quick read, then answer by yes or no. Thank you. Please describe with specificity each and every discriminatory action taken by Associated Bank pertaining to your complaint in this matter that you contained was motivated by your race, color, and or national origin, and including your answer the date or approximate date of the discriminatory action, any witness to the discriminatory action, and detailed summary of each discriminatory action. I read that, I get it, and the questions, please.
Okay, all right. And then interrogatory number two, can you read that one as well?
Okay. Please describe with specificity each and every act of harassment you experienced while working for Associated Bank and include in your answer the date or approximate date of each act of harassment. Any witness to the harassing conduct
All right.
in a
And I just,
detailed summary of each harassing act.
okay. With this, I just want to make sure the record is clear, that you testified earlier today that you did not mention the shirt ripping um, situation in response to your discovery, um, in response to our discovery request, correct?
You did mention that earlier. Yep, you did seize on that. Mhm.
All right, great. Okay. And I have no further questions, but Judge, before I stop, I would like to introduce into evidence a few of the exhibits that we went over.
Okay. Sure. Which ones?
And I'm looking at introducing exhibit 10, 11, 14, 16, 17, 21, 4, and 18, and 30, it was 31.
Okay. And I can go through those separately, Mr. Michelle, and see if you have any objections. So just in chronological order, not the order that he just said. The first exhibit was exhibit 4. So let me show you what that is again. Okay. This is exhibit 4. Do you have any objections to my receiving this exhibit into the record? I think this is the termination letter.
Okay, and please, your question, Judge. Do I
Do you
have
have any objections to my receiving this into the record?
For you to receive it, that's fine for you to receive it.
Okay. Then the next exhibit that Mr. Bullocks mentioned was Exhibit
Judge,
10.
just
Yes.
before you go, again, explanation of the rule of law. That's where I lack. Let me just ask a clarifying question. Do you also meant by any way here, do I agree with the facts of this? You don't mean that.
No.
Thank
Do
you.
you have any basis for my not receiving it as evidence? That's all I'm asking you. Not whether or not you agree or disagree with what the documents say, but if there's any foundation or any kind of other objection to my taking this into evidence.
You may take it as evidence. Yeah.
Yes. So this is Exhibit 10. This is the offer letter. Are there any objections to this becoming evidence?
The offer letter to me, no.
All right, so then Exhibit 10 is received. The next exhibit is Exhibit 11, and that is your application or the application materials. Did you have any objections to this document?
No,
Okay.
that's my application.
All right, so then Exhibit 11 is received. The next one would be Exhibit 14, and that is the email between Kyle Paulson and Nathan Vanden Braden. Any objections to that?
Again, George, bear with me if I have you to repeat this again. And that is only if you should enter it, not that
Right.
if it's okay, if you should enter. For me, yeah, I object to the content of it, but if you want to accept it, that's fine, but that's untrue.
Okay. Then the next one is Exhibit 16. Let me just get there. Exhibit 16 is Barbara McDonald's statement. And again, not that you agree with it, because I know you testified that you didn't agree with it, but any other objections that I should not receive it into evidence.
That's nope.
All
No,
right.
that's what they present, yeah.
All right. So then that Exhibit 16 is received. The next exhibit is Exhibit 17, which was the statement from Michael Tenhaken. And again, I believe he testified that there was things in here that were false or not true, but any objections to my receiving it into the record?
Okay. And and this is as are we accepting this as a as Mr. Taking It being a witness? Is that what we will put here? That he's
No,
a
what
witness to this?
no, what I would take it as is this is a statement that was provided to Nathan, and Nathan's going to testify, and I'm sure part of his testimony will be that he took this into consideration. So it's more what did Nathan know, not necessarily whether or not it happened.
Okay. Again, it's regarding what he said that he hear. Okay. That's about the question that I have here, because the counselor I follow he said here what people hear. Now, what
Right.
he mentioned here is just what he hear discussing. Is that would apply? Isn't that hearsay?
What I think that, and Attorney Bullocks, you can correct me if I'm wrong, but I believe the purpose of this statement is what Nathan believed happened based on what he received from Mr. Tenhaken.
Exactly. It goes to state of mind.
Um, I,
And
I would object to that. I would object to that. Again, Mr. Nathan did not hear this directly. Okay, he did not hear this directly. So he did not this hear directly. This is again, I don't want to again, I don't know what the length that was made up. That's the same date when I filed my complaint. Everybody start throwing something. That's what that is. Mr. Nathan did not hear this. It could
Right.
not be that would yeah, in that sense, I would challenge that. He did not hear
Well,
this
and
directly.
that's not why I would be receiving it. Again, I would be receiving it solely to go to what Nathan understood happened. I understand he wasn't there. And again, I'm not taking this on its truthfulness based on the statement itself. But the only reason I would be receiving it is that this goes to what Nathan knew based on what he was told. And it goes to, as Attorney Bullock stated, his state of mind. What did he believe? We know that
And
Nathan was not there.
Yeah, just for further clarification, uh, Nathan as a witness, okay? That's what it
Mhm.
will be based on this. Is that my understanding?
I believe so.
Yeah.
It's
Nathan is going to
fine.
be testifying about this, and I'm sure one of the things he'll say is he received this, he reviewed it, and he made some conclusions based on it.
Okay. Um, yeah, again, my objection is that this is something that Mr. Takenhaten said that it here happened.
Okay.
Again, me, I know personally that it is not true, but that's something that he made up that it's a it here happened. It's just to complement the case, basically.
Right. And like I said, I'll just receive it to so it goes towards what
In that
Nathan
sense,
Vanden
Your Honor,
Bren's
yes,
statement of
I
mind
would not
was.
take legal argument to tell you that's not my line. Legal argument with regarding evidence, but again, I'm just being cautious that because again, my own point of view, I know this is not right. Would it be valid? Let it be used by the respondent in their advantage. If it's not based on that rule that I just mentioned, that would invalid based on your decision, your authority on this, I would say I would agree to that point, but I think that I have to do that objection on it. If it is hearsay, it's not something directly that Mr. Nathan did hear himself.
Right. And I'll make clear that I'm receiving it for the limited purpose of what Mr. Nathan's state of mind was based on what he received it, not to the truth of what's stated in here.
Go on, George. Yes,
All
Judge.
right. Exhibit 18 is the next exhibit, and that was the email complaint that you made in February of 2016 about the discrimination and harassment. Did you have any objections to my receiving this exhibit?
I'm just quickly reading so many things. I'm reading. If you can go back again with
It's
yeah
your
with
email to
to
HR on February 5th,
yes,
2016 with your complaint
that
of
is
discrimination.
that
Any
is fine.
objections?
No, that's fine.
All right, so then Exhibit 18 is received, and then Exhibit 21, I believe, is the next exhibit.
Mhm.
And Exhibit 21 is emails between Christopher Morris and Nathan Van Braden. And again, I guess it would be similar to the discussion that we had about Ten Haken's statement that this was just things that were told to Mr. Van Braden from Mr. Morris, and it would go more towards his state of mind, not necessarily that what Christopher is saying is true, but it goes more towards what
I want to
Mr.
object to
Morris.
that. Yeah, I want to do object to the judge. At the very end, Mr. Moss, that's basically telling what other people say to him. That's not there to testify. That's making a case. I would object to that. I would
And
object to that here.
and again, I'll just receive it for again the purpose that I stated that it goes towards Mr. Vanden Braden's state of mind.
Okay.
Um, and then exhibit next one. I think there's one more. Oh, exhibit 31. That was the one we were just looking at, I believe.
Yep.
So exhibit 31 are the questions to the respondents' discovery questions. Did you have any objection to the questions being received?
To me, no.
All right.
And then Judge, there's one more, exhibit number 19, which is
Yeah, and I
Mary.
had that one written down and I actually started writing incorrectly. So yeah, I was going to ask you about that because I was checking off as you were telling me, and that was one that I had checked off while we were testifying about it, but I didn't think that you mentioned it. So let me go back to Exhibit 19. Uh, okay, and Exhibit 19 is the email, or excuse me, the well, I guess it was delivered by email, but it was a letter from Mary Coddington regarding your complaint in 2016. Did you have any objections to that, Mr. Michelle?
No, I don't.
All right. So then Exhibit 19 is received. All right. Mr. Michelle, did you have anything else that you wanted to testify about to this evening? We'll hold off on getting into questioning of Ms. Coddington until tomorrow because it's almost 5 o'clock. But is there anything else that you wanted to testify about this evening, Mr. Michelle?
Yes, and I have to, again, I have to mention that with the very first question, I believe that I will try to elaborate as much as I can, where Attorney Bullocks mentioned hiring me, that Nathan did hire me. Now I'm going back to the question itself. As he mentioned, when he hired me, uh, it he related the first questions as though uh, it was regarding does my race,
Right,
do I think or believe is still discriminated against me due to my race,
right,
color, and national origin. I know that's the way that he have to ask that question on his side. That's the way to keep it. I did understand that clearly. What I just want to make clear is that what I want to elaborate upon. It is true that he did hire me for that position. That's not a position of my choosing. That's something the company can use me for it. They see me useful for it. That was the position that's what that was given to me. It was not my choice. I have to say that because I needed a job. That's the first thing they have to say. There's a position they want to fill. So you see what I mean? They scale me down to accept it. So regardless you were somebody hired you because you were black, you from because of your national origin, but there's certain jobs, certain positions that are hard to fill, and that's a lot of overturning. People can use you for that. That doesn't mean that that doesn't mean that you have to see the position that I was giving to say go and pick this one instead, and suddenly you will get a job. Basically, my interview also with as I mentioned, also my interview was it's an affirmative interview, as just to put the term. That's a job that I was gonna get because the recruiter told me if you do this, you're gonna get the job. So I just want to kind of counter that. I didn't have the choice. There was a little bit upheaval between me and him trying to explain. Then he what makes answer by yes or no. That's a job that was given to me to fill. It's basically working, and I'm just gonna say that analogy. You go to a restaurant, you want this, but it's somewhere somebody want to put you. Okay, it's not where you choose. It's someplace they say this one is better. Why don't you go here? Kind of using that analogy there. So in that sense, that's how I did object to that. The way that he posed me that question is have nothing to do then because I was relegated to another position in overall, Mr. Vanden Breden, very soon after, was starting to slight me and starting to find a way to don't let me move to other position. And I'm supporting clearly with Kyle when I asked him to Kyle body with Kyle. That's his body. They go to drinks and everything, and also with my current plan both that I started with him, I followed the protocol. I want to talk with him. Then when I see nothing happen, when I escalate to HR, then that's when he really take a toll. That he set against me to set me out. A lot of things that I didn't do at the branch that I'm supposed to do per protocol that I did not do was because of my origin. Job that I supposed to do actually is because of my origin. I can count on my finger how many times that I unless let me put that clear, I will go over later one of them how many times that I objectively and I mean on my own with one somebody check the vote which is very important. It's strange, everybody stays silent about it, and it's unless I was close by myself with one of the lower position, which is Rachel. It was about that those days that's plain for me to be there where everything is already set, that I can't devote the way it's supposed to be. That's strange because that's a very long year to work where you know you are doing something just to keep your job you are signing. So that's what I did object to. That was a position that was given to me. Of course, it was an affirmative hiring because I know with the recruiter I was set already. I just have to talk with basically to Nate, then I will get that position. So yeah, that's where my objection is. Overall, it's the totality of everything there after the retaliation that I could not go any further than that position. That's all that to put together, and everything else that's like from Mr. Vincent Braden and other thing that from each, even though that I go to the peer where the issues follow me. It started well as soon as Barbara stepped in, and then all the issues kind of reveal themselves again. So that is my objection in that sense that I want to clarify and explain on my side.
All right. Anything else, Mr. Michelle?
That's all I can think of. It's a long day.
Sir, did you have any additional questions, Attorney Bullocks, for him?
I do
All
not.
right. Then, like I said, we'll end for today then, and then we'll start again at 9:30 tomorrow morning. I believe, Mr. Michelle, you'll call Miss Coddington first as a witness, and then Mr. Vanden Braden.
I intend to do it that way, yes.
All right. So then, anything else from either one of you before I let everybody go out?
No, not for me.
Not for me.
All right, then thanks, and I'll see you tomorrow morning at 9:30 then.
All
Have a
right.
great
Thank you all. Thank you.
Thanks,
Bye-bye.
Evening.
You
Bye.
too.